law firm. And John is going to kick things off before our break with this, some comments on entity formation, business organizations, and then we're going to do a little mock client session, the three of us, just so you get a little sense of some of the stuff that we do. And then we'll take a short break, and after the break we'll continue with IP topics that Justina will lead, and then some sort of other that John will be back. John?
Welcome, everyone. As some of the panelists already told you before, corporate entity selection is going to be probably the primary topic that you get the most. So as Marty gave you a little bit of a roadmap here of where we're going for the remainder of the session this morning, we'll talk about the entity selection, the corporate veil. We're going to move into that mock interview, followed by, of course, the all-important break, and then you can see the other topics that we'll address. Corporate entity selection is not as difficult as a lot of people make it. The thing to keep in the back of your mind as a LegalCorp volunteer is that you've got a built-in crib sheet to help you. And this is on page 17 of your guide. It's a spreadsheet that compares 3 of the major entities that we analyze with our clients. The first one is an LLC. Then there's also the C and the S corps. Now, granted, this is not an exhaustive list of all the different entities that you could select, but these are the 3 most common that we tend to discuss with our clients. Again, trying to simplify things. With respect to a limited liability company, I would say that an LLC, with respect to every single client that I've seen in a LegalCorp setting, an LLC works for them. You really can't go wrong with it for the most part. It provides maximum flexibility. So even if you are a 50% owner, but you're feeling charitable and you want to only take 10% of the profits, and you want to give the rest of the profits to, say, your business partner, you can do that with an LLC. With some of the other entities, you can't. And specifically in S-Corp, you can't do that. Another benefit of an LLC is there's pass-through taxation, as some of the other people have discussed this morning. If the entity is making money, that just passes through onto the personal income taxes of the business owners. Most importantly, like the other entities we'll discuss today, it provides personal liability protection. So in the event the company is sued, it's only the company's assets that are at stake, not the personal assets of the individual owners. Now, we actually put our brains together, and we had a hard time coming up with some cons, but we have listed some cons here for LLCs. And I think one of the major ones is because an LLC is so easy to start up, you get some people that may not know what they're doing, or you get some fraudsters out there that are just creating LLCs as a shell to transact their nefarious business. Now, I think that's obviously in a minority of instances, but some lenders and creditors may mandate some heightened standards for people that are an LLC versus, say, like a C Corp. There are also some additional complexities that you may have to deal with as an LLC that you may not have to deal with as part of a different entity. But again, to recap, LLC, you can't go wrong with it for the most part on pretty much every client you're going to be seeing at LegalCorp. C Corporation is another possibility. This is the default election. So if you register with Minnesota Secretary of State's office, you have your articles of incorporation. As a corporation, the default is a C Corp. What this allows is a large number of shareholders, and this type of entity would be the best suited for an individual who's seeking to bring their company public. They're the next Facebook, perhaps. They want an IPO in 3 or 4 years. They're very aggressive. This is not the correct entity for most people, but in those circumstances, that would be the correct entity. The main downside of a C Corp is that it's subject to double taxation. So the money the corporation makes is taxed once, and then when there's distributions, that's taxed again, hence the double tax. And the little nice icon here of Uncle Sam funneling the money into it. An S Corporation. This is a special election that you have to make with the IRS. And so while you will file your articles of incorporation with the Minnesota Secretary of State's office, you have a separate filing with the IRS that basically says, please tax me as an S corporation. Now, the benefit of an S corporation is that it's taxed just like an LLC is. There's pass-through taxation. So what that means is, again, as a company makes $1,000, then there's just $1,000 that are taxed as part of the personal income tax return. Now, there are some also additional tax savings on an S Corp that are not available in an LLC. So if you have a company make $100,000 for the year, and the only owner of the company takes a salary of $50,000, that owner would pay payroll taxes on their $50,000. But the remaining $50,000 of profit of the corporation would not be subject to those payroll taxes. So that can be a major tax benefit. At the same time, there's also a major con and a pitfall with respect to that, because you have to document the reasonableness of the salary. It can expose the client possibly to a greater risk of an audit or liability after an audit occurs. So for most clients, when they don't know exactly what they want to do, or they may not be the most sophisticated, an S Corp may not be the best option for them. Another pitfall of an S Corp is that there are limitations to only having one class of stock and so many shareholders, and I believe we're at 100 right now, if I recall right. So if you're looking to expand rapidly with multiple shareholders and you think you're going to go over 100 shareholders, an S Corp is not the right vehicle for you.
But I will point out with the documenting the reasonableness of the salary. I mean, we get a lot of business owners who have us. I mean, as a law firm, help them set up S corporations, and that you can get really significant payroll tax savings, whatever, or self-employment tax savings by setting up a service corporation in that way. But again, it's something that if for the clients who walk into these clinics, they're probably not going to have the sophisticated ongoing help, and keeping it simple is a real benefit. So LLCs can be really good.
Stephen?
Corporation or another LLC or something. And so I do M&A. Every single time that we've ever had a target company that is an S corporation, they've screwed it up. They didn't realize it.
Can you either step to the front of the room?
Oh, yeah, Steve. Actually, you know what?
Here's two over here.
I'm sorry.
No. We have just the thing.
Usually I'm shy at people when I talk.
Exactly. For our guest, is this on? Oh, great. Okay.
All I was going to say was one other limitation to S corporation shareholders. I think you probably didn't get into this because it's beyond complication for what you would normally see in a clinic, but you can't have a corporate entity be a shareholder of an S corporation. And people will inadvertently screw that up, right? They'll form a business, then one of their business partners wants to invest. Maybe their business partner is a little more sophisticated. That business partner will choose to invest through maybe a corporate entity that they already own. When that corporate entity becomes the second shareholder in S corporation, you've now blown the election.
And that's something that I point out to people too. I mean, sometimes there are advantages to S corporations, but S corporation, it's possible to screw it up, and it's you're letting this person go, and they're going to go off and file an S election. Maybe they have a bookkeeper who's going to help them do that. With an LLC, the tax part of it is completely self-effectuating, and so you can't screw it up, and it's a real advantage to people who don't have the sophisticated advisors.
Another pitfall to an S corporation, if you are a 50% owner, you have to take 50% of the profits. There's no flexibility there. And that's, again, one of the pitfalls of an S corp that an LLC doesn't have. At an LLC, you've got maximum flexibility of deciding how those profits are going to be split. Partnership, I'm not going to discuss it at length, but there are certainly other options for partnerships. Depending on what type of specialized business the person is in, a partnership could be a viable option, but frankly, in my 3 or 4 years with LegalCorp, I've never seen a situation yet where I've had to discuss a partnership. One of the most common things you'll get is a client coming to you and saying, well, I've just filed, or I want to file an assumed name or a DBA with Secretary of State's office. I just want to be a sole proprietorship. I've heard that term before. That's okay, right? I'm protected. I've got personal liability limitations where they're not going to be able to pierce the corporate veil. And you have to back up a step and say there is no corporate veil. When you are doing business as yourself, you are still personally liable. And so just filing an assumed name of the Secretary of State's office is insufficient to give you that personal liability protection. Now, it can be sufficient in the event there's an underlying business associated with that assumed name, but again, you still have to organize an LLC or incorporate a corporation for that protection to occur. Corporate veil means exactly what all of us probably recall from law school, that again, there is that personal liability protection in the event that there is a lawsuit or some other liability is triggered on behalf of the company. They're not able to run through the company into a person's personal assets. Now, there's obviously steps that you need to take and corporate formalities you need to follow in order to obtain these protections, in addition to the filing of your entity with the Secretary of State's office. Oftentimes, you are going to want to have a federal and possibly a state tax ID number issued. You're going to want to have a separate bank account, and these are all things that you can counsel the clients on in terms of how to keep their personal assets separate from the company assets. There's a whole host of other reasons, things that you need to do in terms of adequately capitalizing the business, indeed running it as a separate business, things like that. These are all things that are, again, pretty common sense for most of us. The one thing that I have on here on the bottom is personal guarantee, and the thing to keep in mind with clients and remind them is when they sign a personal guarantee, if it's as part of a commercial lease, if it's part of a line of credit, heck, even if they're applying for just a credit card for the business, there's personal guarantees almost in every one of those situations. And that is going to wash away that personal liability protection, so to speak, because the person will be personally liable for any liabilities of that transaction. So I think that is helpful to explain to clients. Yes?
Quick question, John. What do you tell clients, or what is your rule of thumb for what adequate capital is?
Adequate capital, great question. It differs based on the business. If you are starting an insurance company and you're looking to be the next progressive insurance company, then your capitalization requirements are going to be far different than if you are just a sole proprietor of, say, a retail shop. There's no hard and fast number, but ultimately, the questions that you can ask a client are what type of business are you doing, what type of liabilities do you expect to have, and depending on those circumstances, usually it's a business decision that you help the client make that determination. Now, if anyone else has maybe a better rule of thumb, that's my approach. I'm not saying that's the only approach.
And I sometimes I'll mention that, but and generally my advice is that there are various aspects that if it ever came to to court that a judge would look at, but that for most businesses, I think I don't spend a lot of time talking about adequate capitalization because that's so fact specific, but it's really sort of respecting the corporate entity and where the funds flow and having the bank account and a couple other things that John will talk about that I think are really sort of the fundamental things.
And as part of some of the banking institutions, they will require minimum deposits to create a company checking or savings account. At the bare minimum, that should be your minimum capitalization requirement, regardless of the circumstances. I'm not saying that would be proper for every company, but I know some banks have a $1,000 or $2,000 limit. That at least sets a baseline that you wouldn't want to go under. Corporate veil, in terms of how to protect yourself from personal liability with unknowingly personally guaranteeing a transaction as part of say, a contract, is informing your clients how to properly sign a contract. And you would be amazed. I've got Fortune 500 companies where I've had individuals that do not know how to sign a contract properly. We've been involved with litigation where we've had, again, a Fortune 500 company, a client of ours, that has improperly signed a contract. So the difference here is on the top element, we have the person signing individually in their individual capacity. There's no mention of a company on there at all. For all you know, it's Jane Smith saying, I am contracting on behalf of Jane Smith. On the one below, we see that Jane Smith is signing on behalf of her capacity as president of Corporation ABC. And that is the proper designation for clients to be signing, is that when they're signing contracts, it should be very clear that they're signing in their capacity as an officer or a manager of the company and not themselves. I should just also state where this commonly comes up and where I've seen this issue challenged is on a commercial lease situation, where a commercial lease has been signed individually by a person. All right, checklist here. So this is the overall thinking when you're sending the client away at the end of your 30 minutes, marking down your checklist of the things that you can give them as homework or takeaway points. So they obviously need articles of organization if they're going to do an LLC or incorporation if they're doing a corporation. And some of the other elements here are somewhat optional. You know, do they need bylaws or a member control agreement? If there's multiple owners, my advice to clients is always get a member control agreement. Bylaws are obviously the ground rules of how the corporation is going to work or the LLC is going to work. Those are recommended but not necessarily necessary if you were going to have a member control agreement with all the members signing. There are different practices, I think, based on attorneys on whether they both would do bylaws and member control agreement, but the ultimate idea is that you're helping establish the corporate formalities. Board minutes establish, we authorize so-and-so chief manager to go open a bank account, to obtain insurance, to hire an attorney if they need to, things like that. Stock certificates, they're optional, especially in LLCs. Sometimes they're a little unwieldy because you're dealing with membership interests. Tax IDs, I generally recommend federal tax ID numbers, and depending on what type of business the person is in, they may also need a state tax ID number. Those are very easy things they can go online and do for the most part. Bank accounts, they can set up their own bank account. Licenses and permits, this is often something that you're not going to be equipped to give the most accurate and best advice on because you may not be an expert in the particular field that the client is going into. What you can do, though, is just raise the issue. Have you found out if you need any special permits or licenses for this type of business? I advise clients, have you checked with the state of Minnesota? There are people whose jobs are to know the front and back of these regulations and statutes. That is their entire job, and they're more than happy to work with you generally if a client was to call up and ask questions.
And I will point out that in the this guide to starting a business, which is great, there's about a 20-page section in the back called Directory of Licenses and Permits. It has every state agency, basically for a business, by category of type of business, where they might want to call to get information about licenses and permitting, and that's been very helpful in directing people to the right resource.
Yeah, especially if they have anything related to a medical or professional type field, that should be a red flag for you to make sure that you're raising that issue. Insurance, down at the bottom, I like to explain to clients that insurance is meant to protect your assets, and unless you're mandated by a statute or contract to have insurance, having insurance is purely a business decision for you. So when you're first starting out, you may decide that you don't want insurance. But once you start obtaining some more assets, you may want to obtain some insurance. Obviously, there are pros and cons to whatever approach you take, but I think sometimes insurance brokers are a little overzealous on overselling insurance policies.